Welcome back. Now, while the opposition mounts pressure on the government to bring in the pending caste census, the Supreme Court has also delivered a landmark judgment on caste classification. The apex court has upheld the state's right to subclassify reserved category. This includes the scheduled caste and the scheduled tribe groups here. A 7-judge constitutional bench on CJA overruled the EV Chinnaiah judgment in a 6-1 verdict. This is to ensure that depending on their backwardness, the maximum benefit is guaranteed to those belonging in the reserved category. The court also observed that members of the SC/ST often do not climb up the ladder due to discrimination. Therefore, the ruling now allows quota within quota to break down now that the states are permitted to introduce sub-classification within the reservation of SCs on the basis of groups which are deemed more disadvantaged than others. Now, all the empirical data must support the sub-classification. The bench was also unanimous on the view that sub-classification must not be based on political bias. Interestingly, to guarantee equality, the top court has also mandated the states to bring about a policy to ensure that the creamy layer of the SC/ST category is kept out of the quota subclassification, violation of which may even attract action. Justice Gawai concluded the verdict today and said, I quote, "History shows that when ethics is faced against the economy, victory is always that of the economy." To break down what is a landmark yet a very complex verdict, let me go across to my guests. I'm being joined by Kapil Sankhla, Supreme Court lawyer, and Binay Singh, author and political analyst as well. Kapil Singhlaji, I'll come to you first. Could you break down what this means for our viewers at this point here? How unprecedented or how significant is this 6-1 verdict which has overturned a previous judgment and has ensured that there will be quotas within quotas?
Lovely question. Short answer, it is like this. There are certain significant parts in the judgment which kind of overrule what was the long-standing status quo between the union and the state. One was that in this case, Article 341 stipulated that the president shall rule regarding questions pertaining to scheduled caste, scheduled tribe quota. This has now been, that power is now being given to the state. Initially, the power was with the parliament to then make good whatever the advice or the order of the president was. This has now gone to the state. Historically, though the same was decided by the president and the parliament, the groundwork was done by the state. Now the groundwork, not only the groundwork, but the decision-making power is with the state. And that is a huge shift from where we were prior to this judgment. Second very important thing. It was said that the scheduled caste is one homogenous group, which means that there are no sub-classifications. We do know that there are sub-classifications in the scheduled caste as well. Most are untouchable, of course, but some are untouchable within the untouchables, as unfortunate as it is. But what is now being recognized is that there are sub-classifications. There could be certain classifications in the scheduled caste and scheduled tribe that perhaps become economically stronger or socially stronger and not the other classes. So now it has been so decided that the state can decide and look into these sub-classifications. So this is good and bad at the same time. Good,
that's a brilliant breakdown.
Recognize that there
that's
are
a brilliant breakdown, Mr. Sankhla.
Right, please.
Okay. That's a brilliant breakdown, Mr. Sankhla. Explained it perfectly. Yeah, please go on. Please go on.
Yes, please. So the other aspect is the good and the bad is very important. The good is that we have finally recognized that there are untouchables within untouchables as well. But the negative is that once you start breaking down the whole community of scheduled caste, you're actually breaking down Hinduism even into more minute details. What you're basically doing is, one, we had this Varna system and the caste system. Now we have lower caste system, which is being recognized. That's probably going to lead to some problems. The second is that you say that it would not be decided by political reasons of the state. That unfortunately would be very difficult to control. It's always easier to control when there is one head, but it's very difficult when there are various heads with various issues pertaining to various states, and they're deciding on political angles. That's my take, please.
So, Mr. Sankhla, essentially, I mean, as the famous saying goes, India is a place where everyone is in a race to categorize themselves as most backward. That's the paradox and that's the irony. But in terms of operational impact of this verdict, does this now give powers to state, for instance, a state like Maharashtra, to now come up with a sub-quota for Marathas, which has been a long-pending political demand within the existing reservation rubric for SCs and STs? Similarly, does it empower a state like Haryana to do so same so for Jats at this point? Or are there now checks and balances still within the system?
Again, that is exactly what I was saying, that the difficulty that we'll face is now that the states have the power to decide, though there is a check saying that it cannot be due to political reasons and there has to be some system into place. But that system is again state-centric. So, for example, a state of Haryana, if it so decides that in our considered view, Jats are minorities or Jats are require status of a scheduled caste or a scheduled tribe, and the justification is given as far state level is concerned, that justification would hold good. Now, for example, Maharashtra again. So once that happens, you start creating difficulties which are state-wise. So therefore, as I was saying, was perhaps though it is time to look at the reality as far as the scheduled caste and scheduled tribe is concerned. But I think it causes more difficulty now where the states have been given power to justify their stand, which of course would be more politically hinged than economically hinged or for the purposes of benefits of the scheduled caste and scheduled tribes.
Okay, let's now look into the political aspects of this. Vinay Singh, is this a very important counter for the government at the time when it's already facing a lot of demands from the opposition for bringing a caste census? Because now state governments, as we discussed, you can have quotas for Metis within the current framework, you can have quotas for Marathas at this point as well. How does this play out politically?
Look, caste is a very, delicate subject, but it's very important too. So simply you can understand that there is diversity in this country and there is diversity within diversity. So we can call it as quota within quota or reservation within reservation. So why that is there? So previously the court was the highest court, the Supreme Court was in the view that if you take SC as a group, as a whole, so it is a homogeneous identity, but that is not at the ground. There is diversity, it is not homogeneous. And if you even took a particular caste also, in OBC or in forward caste or in SC or ST category, within that particular caste, there are categorizations. So diversity is there, and I think the order of the Supreme Court, that it is a very timely intervention, and it will pave way for the welfare of the marginalized, those who are not getting their share of benefit of reservation. So I think this is a very timely thing. And one more thing, that from caste to caste, why it is not homogeneous? Because if you take SC as an example, SC group as an example, there are several castes, and each and every caste, they differ in cultural aspects from the other. They differ in economic status from the other. There are inequalities among them. So if the Supreme Court has come up with this and they are opposite to their own view, what they have in the past, I think it's a very welcome step, and it's a very welcome.
I think there's no doubt. There's no doubt in this short conversation that we have had, both Mr. Kapil Sankhla and Binay Singh. There's no doubt in the merits and the wisdom of the Supreme Court when coming up with this very landmark judgment here. The question now is, in terms of its implementation, the Supreme Court expressly cautioned against it being used for political purposes. One fears that exactly what may happen here, especially with state elections coming up in states like Maharashtra and Haryana. Thank you so much, gentlemen, Binay Singh and Mr. Kapil Sankhla as well, for joining me with your perspectives on this quick story.